Hey folks, welcome back to the channel. In today's hearing, a defendant tests positive for alcohol just one day after signing bond conditions that explicitly prohibit drinking. But instead of denying it, he reaches for something far more original, the grandma defense. According to him, it was nothing more than a harmless, heartfelt toast with his ailing grandmother, hardly worth mentioning, let alone sanctioning. But as the court presses for details, the timeline blurs and the drink count multiplies. Let's watch as a simple violation spirals into a full-blown credibility collapse, one sip at a time.
Mr. Hamlin, there are some sanctions, potential sanctions against Mr. Proctor. Could you state for the record the nature of those?
Thank you, Your Honor. Your Honor, on May 16th of 2025, Mr. Proctor tested positive for ETG at Great Lakes Screening and Services. That sample was sent in and returned with positive confirmation from Redwood Toxicology on May 20th. Also on May 19th, Mr. Proctor did admit to drinking wine the day before the drug screen. He admitted that during an office visit. I would also like to note that Mr. Proctor is currently on bond conditions which allow him to participate in our program.
Is there also a second potential violation?
Oh, yes, Your Honor. Thank you. On May 20th, Mr. Proctor was pulled over by the City of Gaylord Police Department and cited for a DWLS. He did advise of that situation or incident rather during an office visit too. Again, he is still on bond conditions to participate in this program. And if the court doesn't have a copy of that police report, I can hand that over.
I do have a copy. All right, Mr. Proctor, Mr. Brown, you've heard the allegations. Mr. Proctor, you have the right to have a hearing on those matters. That would be in front of me as a judge. You do not have the right to have a jury trial. You have the right to see, hear, and question the witnesses against you. You do have the right to be represented by an attorney. You have the right to get a subpoena from the court to require witnesses to appear and testify on your behalf. You could testify or you could remain silent, and the silence could not be used against you if you chose not to testify. And the burden of proof of a preponderance of the evidence would be on the prosecution. You understand the rights that I've just given to you?
Yes, sir.
All right, Mr. Brown, how does your client wish to proceed today?
Your Honor, at this time, I believe he is going to make admissions to the drinking. However, we would request on the driving on a suspended that be adjourned, as it appears he may have picked up a new charge on that, which is currently pending.
All right, Mr. Hamlin, do you wish to proceed as to the DWLS charge if it makes an admission to the drinking charge?
Yes.
All right. All right, we'll take the plea as to the drinking charge, and we will postpone and adjourn the DWLS to allow that to work its way through the court system, and then we'll readdress that in the future. Mr. Proctor, would you raise your right hand, please, so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right.
Yes, sir.
You've heard your lawyer indicate that you wish to admit this drinking violation. Is that correct?
Yes, sir.
Has anybody promised you anything or threatened you in any way? Has anybody threatened you in any way to get you to enter this plea?
No, sir.
You're doing this of your own free choice and free will?
Yes, sir.
All right. Can you tell me what you did regarding May the 16th that makes you believe that you're responsible for drinking on that date?
I just messed up and had a drink. I had a glass of wine with my grandma. I dropped dirty.
You knew that you were on bond conditions that prevented you from drinking at that time?
I was on the original bond conditions, yes.
All right. All right, I will accept your plea. Find that you've given me that plea knowingly, intelligently, and voluntarily. Mr. Hamlin, how do you wish to proceed as to disposition?
Just a moment, Your Honor. Your Honor, I'm going to ask that the prosecutor give his notations on this.
Mr. Portier?
So, Your Honor, given the fact that he signed and acknowledged the bond conditions for the program on May the 15th and 24 hours later tested positive for alcohol, one of the conditions that's actually listed as number 3 is you are not to purchase, possess, or consume any alcohol. I think at this point, given how quickly that violation occurred and the fact that there's a pending charge and we're adjourning the other portion of this, I think it would be wholly appropriate at this point for Mr. Proctor, when he gets back to the state of Michigan, that he turn himself into jail and a new bond be issued at that point.
Mr. Brown, your response?
Hi, Your Honor, I did have conversation with Mr. Proctor. He knew that he had messed up. I believe his grandmother is in poor health. They were talking, they sat down together and had a glass of wine. He was not driving, he wasn't getting drunk or anything, but it was still against the bond conditions. He knew that. I would give him credit here for not trying to say it's a false test or something like that, and that, you know, he was very straightforward about it. He knew the potential consequences here, yet he still didn't try to cover it up. So I would ask court to consider that when imposing it. And if Mr. Proctor can elaborate on that as well.
All right, Mr. Proctor, you also have the right to tell me what it is that you think I should know prior to the imposition of sentence. This is your opportunity, sir.
Dustin, did you want to say something? Looks like he might have froze up.
Joys of technology.
Your Honor, I'd like to say too that I did tell Mr. Proctor if he is in a dead zone or knows where one's coming up, he should be in an appropriate spot for court.
Mr. Proctor, can you hear us?
I would like to say that I didn't have the glass of wine after Thursday. I had it on Thursday. I had it on Wednesday. Going above the hill.
You're gonna have to try to say that again, Mr. Proctor, and speak a little more slowly.
I think we lost him.
Do you have a telephone number for him, Mr. Brown?
I do.
Did you call him and tell him to get on his phone as opposed to the whatever he's doing now?
Sure, Your Honor. Just give me one moment, please.
Can you hear me?
I can, Mr. Proctor.
I'm so sorry. I always have service here. Pull over somebody.
All right, Mr. Brown is here. Go ahead, Mr. Proctor. Why don't you repeat what you tried to say before?
I was trying to let you know that I did not have the drink after I got into drug court. I understand it was still on bond conditions, but it was not after I got into drug court. It was before I got into drug court. I'm still taking ownership to it. I wasn't supposed to, and I messed up. I get that, but it wasn't right after I got into drug court.
It's on May 16th, right?
I dropped dirty on May 16th. I had the drink on the 14th.
You still didn't have alcohol in your system from a drink on the 14th when you tested on the 16th.
I tested dirty like that before. Last time I was in drug court.
If you're going to tell me stuff like that, things are not going to go well.
I'm just saying, I didn't drink the day of drug court.
Is that what you want to stay with?
I'm taking full ownership of drinking.
Full ownership of what? That you drank on the 14th and tested positive on the 16th?
We'll go with 15th. I take full ownership for drinking, and I shouldn't have drank.
Okay, Mr. Proctor, do you know how alcohol works in the body?
I don't know how anything works in the body, sir.
Yeah, you drink it and it goes away relatively quickly. Like within an hour of drinking, you've lost a substantial amount of alcohol that you consumed already. If you had one drink, probably within 2 hours, there's no alcohol left in your body. You can't test positive a day later from a one drink of alcohol. So you're lying to me someplace, or you're lying to yourself. Either way, it's not a good thing.
I had more than one drink, but we'll go with I had
But-
to drink on drug court, so I apologize.
It's not a we'll go with. Tell me what actually happened.
I had to drink.
How
on
much
drug
did you
court.
drink, and when did you drink, and where did you drink?
I had three drinks.
When?
Drug court day, Thursday.
What time?
Well, I got out of work at 4, so after 4.
4 in the afternoon or 4 in the morning?
Afternoon.
When did you test?
Friday at 8, I think.
So what did you drink? It's going to still be in your system 12 hours or 8 hours later.
I had 3 drinks. That's all I had. My grandma's right here with me.
Well, so far we've gone from 1 to 3. You want to try again?
I only had 3 drinks.
We didn't have that.
Here's how this process works. It's not how little can you tell the judge to make it happen for the way you want it to go. It's you tell me the right way the first time.
I understand, sir. I'm sorry.
How old are you, Mr. Proctor?
35.
Have you not figured out how to tell the truth yet?
I have.
Well,
I apologize.
I don't think you understand it then, because you just lied to me in court. Anything else you want to say, Mr. Proctor, on your
No,
own
sir.
behalf?
No, sir.
How long are you going to be out of the state, Mr. Proctor?
I will be back on Friday.
Friday is May 30th.
Yep.
What time on Friday will you return?
I won't be returning until 8 or 9
In the
Depending on
morning or
drug
in the
testing.
evening?
in the evening, depending on drug testing.
Saturday morning, 8 a.m. Report to the jail.
Your Honor, can I ask for a 9 a.m. if he has to drug test? That gives him reasonable time to do that. too.
Yep. 9 a.m. so that you can drug test Saturday morning. Report
Okay.
to the jail for 2 days. You'll be there Saturday and Sunday.
Can you release him Sunday after 10 a.m.?
Yep.
Thank you.
So 9 a.m. Saturday till after 10 a.m. on Sunday. You understand, Mr. Proctor?
Yes, sir.
That's not only for drinking, but that's for lying to me. It gets worse as it goes along, so don't continue that behavior. Do you understand?
Yes, sir.
All right, that's all for today. Thank you, Mr. Brown.
Thank you, Judge.
That wasn't a hearing, it was a moving target. He couldn't hold the line on a single fact, and by the end, the court wasn't reacting to the drinking, it was reacting to the performance. And while Grandma wasn't present, she was the unseen co-star of a performance that the judge absolutely was not clapping for. When defendants change their answers, how many versions do they get to tell before the court stops playing along? If someone is willing to twist the narrative this early, what does that say about their ability to follow the rules down the line? Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.